basis for that charge is an alleged violation of a no trespass order delivered to him by the Keene Police Department. It's our position on this motion that that no trespass order is in violation of Mr. Colson's constitutional rights and also is in violation of statutory rights and reflects a fundamental failure to appreciate the division or separation of powers by the Keene City government. Just that the pertinent procedural facts here, none of which I think are disputed, is that Mr. Colson was stopped by an officer of the Keene Police Department on Central Square and told that he had violated an ordinance prohibiting skateboarding. That officer then delivered to Mr. Colson a document that's printed, also filled in hand, basically stating that you are hereby notified that you are prohibited from entering or remaining upon the premises referred to as the common Central Square, Keene, New Hampshire, for a period of 1 year. And that Mr. Colson was, this letter was issued, Mr. Colson refused to accept it. The city on this motion has alleged that the procedure followed by the police officer, in this case was authorized by the city manager. I've seen no written verification of that, but I have no grounds to disbelieve that. And first, the final act here is the claim is that within that 1 year, Mr. Colson was again seen on Central Square, and that is the basis for the criminal trespass charge. Now, in terms of the, I think in terms of the various statutory and constitutional violations engaged in by the city, I want to really put them into two categories. The first category is that Mr. Colson was entitled to an impartial adjudication as to whether or not he violated that ordinance. He was entitled to ultimately to a judicial determination of violation, and that determination never occurred. The police officer in this case acted as the prosecutor, the judge, the jury, and also as the enforcement person. There was no attempt to separate out powers. The city essentially placed in one individual that complete damage. Mr. Colson was never, this letter does not provide for, nor as far as I can tell, does the city ordinance provide for any type of challenge of this letter. There was never a determination, an objective determination made that in fact Mr. Colson engaged in violating the ordinance. The issue on this motion is not whether or not he violated the ordinance. The issue is that he had a right to a determination as to whether or not a determination by somebody other than the enforcing police officer that as to whether or not that violation had occurred. And that right was denied, and as far as I can tell, in this much Mr. Colson's case is not atypical, that violation seems to be systemic in terms of the city of Keene's procedures. Now, secondly, and let me just say one other thing. In addition to being, Mr. Colson stating that he could not go into Central Square is a clear restriction upon his liberty. So clearly implicates the due process clause. So clearly there was a right to a hearing before the deprivation. But putting aside the Constitution, if you look at the statutes involving the enforcement of ordinances, and I'm referring in particular to RSA 31-39 C, in parentheses, Roman numeral 1. First of all, the city has a right to adopt an enforcement scheme for ordinances. So that enforcement scheme has to be adopted by the legislative body. It can't just be promulgated by the city manager. And we've received no evidence, or has there been a claim, that the governing legislative body in the city of Keene adopted this enforcement scheme. Secondly, under RSA 31:39-C-3, if the individual, if there's no resolution through this enforcement scheme, then the next step is a summons to court. And clearly there was no resolution here. I mean, Mr. Colson didn't even accept the letter, much less did he acknowledge any guilt. So at that point, legally, both under the statute and under due process, the city's obligation was to issue some type of summons or to initiate a court proceeding so there could be determination by somebody other than a police officer that Mr. Colson had in fact violated the ordinance for any restrictions were placed upon his liberty. Now, the second set of problems that are fundamental that relate to this enforcement scheme has to do with penalty. In other words, there is nothing in the law that permits this type of no trespass order as a violation of the city ordinance. The statute, and that is RSA 31:39 in parentheses Roman numeral 3, says that there shall be, quote, suitable penalties not to exceed $1,000. And the city of Keene charter talks about the imposition of financial penalties. There is no authority that I have been able to find, or that the prosecutor has pointed out, that provides for this type of a no entry order. And again, one of the problems here is that in the absence of any type of authorization, any type of legislative authorization, you leave unlimited discretion in the hands of the executive, in the hands of the executive body. The proper role of the executive body is to enforce the penalties that are in place, not to create the penalties. And again, it's that complete failure to delineate roles that has occurred here. And as far as we can tell, I mean, although the printed form says 1 year, what is to prevent the city from saying 5 years, or 10 years, or 6 months? I mean, there's essentially unlimited authority that's been given, whether it's in the hands of the individual officer or in the hands of the city manager. It doesn't matter, because they're both enforcement agents. They're not the ones that are supposed to be establishing the sanction. So that this attempt to sort of create your own remedy, certainly without any precedent in state law, or even as far as I can tell in local ordinance, it's again a violation of the law, and it's also a violation of the Constitution, because it gives the enforcement officer unlimited discretion in limiting Mr. Colson's liberty rights. Now, the final issue here is the issue of First Amendment rights. And again, we discussed these to some extent in terms of Mr. Freeman's cases before this court several months ago. The New Hampshire Supreme Court has emphasized the paramount importance of public squares and public streets, such as Central Square, in the engaging of free speech activities, and the very strong burden that any type of enforcement authority has to meet in limiting those free speech rights. Now, in this case, it is not a coincidence that Mr. Colson was a member of the Robin Hood group, and that he was engaged in Robin Hood activities. And in fact, the two complaining witnesses against Mr. Colson are both parking enforcement officers. Now, under normal circumstances, one would think that parking enforcement officers would be engaged in focusing on vehicles being parking meters. The reason, and not on whether or not somebody is improperly in Central Square, the reason that they are essentially making this complaint against Mr. Colson is because they are trying to prevent him from engaging in Robin Hood activities. Now, as I think the court may know, Mr. Colson is a defendant in the civil action that the city of Keene has brought in Superior Court based on these Robin Hood activities. But in that proceeding, the city has been forced essentially to acknowledge that he has First Amendment rights in terms of what he's doing in a public place. So this is essentially, this procedure, among other things, is an attempt to engage in end run around all the First Amendment issues by trying to turn this into, by simply sort of essentially giving the city the right to kick him out of the public square. And those are issues in terms of the First Amendment protection.
Well, if someone were to be observed committing an assault on someone else on Central Square,
correct,
and charged with an offense,
correct,
and that person also was a First Amendment activist,
correct.
Wouldn't the state be permitted to arrest the person and impose obligations on him to? They're discrete issues, aren't they? As a consequence of behavior that has nothing to do with exercising First Amendment rights. It'd be one thing if that person was out there on a soapbox making a speech. It's another thing if he's beating somebody up.
Well, first of all, this has everything to do with exercising First Amendment rights, because he's in Central Square engaging in those First Amendment rights.
Well, that's why when we had the quick meeting at the bench, the question I had is about whether, to what the extent to which facts have to be presented here today. I mean, we're making arguments that are based on fact, and I don't know what the state's position is on those facts.
Okay. Your Honor, first of all, he has a First Amendment right to be in Central Square. I mean,
I'm not arguing that. I'm just saying what you're making an argument that has a lot of factual underpinning to what you're saying that I doubt is going to go unchallenged here.
Your Honor, first of all, I respectfully differ with that for many reasons. I want to go back to the court's analogy about somebody engaging in assault in Central Square. If you engage in assault in Central Square, then you can certainly be arrested for that, regardless of whether you're exercising First Amendment rights or not.
Excuse me. I don't know what Mr. Colson was. I don't even know, based on the record, if he was in Central Square. I mean, that's what we talked about before. I don't know if he was on Central Square or in Central Square. I don't know what he was doing. I don't have any evidence of what he was doing. I have people's assertions, but I have no idea what he was doing.
Your Honor, what I'm saying, it doesn't matter what he's doing in Central Square. First of all the other arguments I've made about the fact that this violates due process, violates state law in terms of ordinances, violates the separation of powers, none of that has to do with any facts at all. And so the First Amendment argument, as far as I'm concerned, is reason number 6 why this practice was unconstitutional. And perfectly, if the court feels that can't be decided without factual testimony, I'm happy to stick with the first line. But the point I want to make is about the First Amendment issue is the issue there is not whether he was engaging in First Amendment activity at the time he was given this no trespass order at the time he was arrested. The issue is the motivation of the city. And my argument here is that the city's motivation in this case clearly is to punish him because of the exercise of his First Amendment rights. But inasmuch as that issue does depend on facts, and I'm prepared to put that aside. I'm just saying that just is another reason, but I mean, the due process fact that anybody, I don't care whether it's Mr. Colson or anybody else, I mean, all the other arguments I'm making,
my comments are limited to the latter.
Well, I appreciate that. You know, I just want to briefly respond to the arguments that the state's made in its objection to my motion. First of all, they cited the city manager statute, and they've cited that part of the ordinance, that part of the city charter that relates to the authority of the city manager. All of those provisions, as they're applicable here, are just extremely general delegations in terms of enforcement authority, in terms of enforcement authority. None of those come close to giving a city manager the authority to establish what the punishment should be. Certainly none of them, you know, go to the fundamental point that Mr. Colson is entitled to a hearing before he's adjudged to have found to have violated the city ordinance. None of those go to the fact that there is a specific statute dealing with enforcement of ordinances that sets specific requirements, all of which the city has violated, in particular by failing to have the legislative body promulgate whatever the enforcement scheme is going to be. The city, I think, as I understand their position, is saying, well, this is a civil, that the underlying scheme is a civil scheme and not a criminal scheme. But in terms of the due process clause, that doesn't matter. Your right to due process is not a right that's limited to criminal sanctions. It applies to any type of restriction on your life, liberty, or property. Now, finally, if this was a case where Mr. Colson had violated some type of ordinance or law relating to driving, and was told that, you know, given a letter by a police officer saying you can't drive a vehicle for a year, without any type of option of going to a hearing or having any type of mutual adjudication of that, we would all be outraged. Because clearly that would violate the due process rights of the driver. Mr. Colson doesn't have a vehicle. He's not a driver. I mean, for him, for a lot of other people, being able to walk across Central Square is every bit as fundamental as the right to drive a car. And to have that right taken away without any right of process, without any type of a hearing, based upon a set of sanctions that apparently were devised by the person supposed to be enforcing the sanctions, is just a violation of both state law and the right to due process. And I said, if I think I'm prepared to just deal with those issues now, and if court rules against us, reserve the First Amendment issue for some type of adventure. Thank you.
Thank you.